Hello, my name is Faizah, and I will compare and analyze two legal cases in Ontario education. Case 1 is in between on the Ontario College of Teachers and member Rachel Adam Vandenberg, who was employed by the Waterloo Region District School Board. Following allegations were placed against her under professional misconduct as defined by OCT Act 1996 in the Regulation 437/97. She was alleged on the basis of the following agreed statement of facts, which include inappropriate conduct of the member with the students, parents, staff, and disclosure of confidential information. Inappropriate conduct with students includes speaking in a harsh tone, giving them often detentions, discouraging and criticizing students, frightening and intimidating them, and disclosing information with other students. With parents, it includes disrespecting and embarrassing them and speaking in a sarcastic, loud, and condescending tone at multiple occasions. She also yelled and screamed at staff and spoke in a condescending tone. She also disclosed a student's name and assessment information in a public conference. She admitted that her actions constitute professional misconduct and pleaded guilty to the allegations. The discipline committee found her guilty of professional misconduct, in particular the Ontario Regulation 437/97, subsections 1, 5, 6, 7.2, 15, 18, and 19. The penalty that was imposed was a reprimand. Her certificate of qualification and registration was suspended for a month, and prior to returning back to teaching, she was supposed to successfully complete 2 courses, including classroom management and sensitivity training. Case 2 was between the Ontario College of Teachers and member James Robert, who was employed by the TDSB as a middle school teacher. Following allegations were placed against him under professional misconduct. In November 2011, the member was arrested at his home and was charged with 5 counts relating to accessing, attempting to access, and possessing child pornography. Items seized by police included written stories and movies on his laptop that included child pornography. The Ontario Court of Justice found him guilty under the following counts, and he was sentenced to 6 months incarceration followed by 3 years of probation. He acknowledged that the admitted facts constitute professional misconduct and pleaded guilty to the allegations against him. The discipline committee found him guilty of professional misconduct under the Ontario Regulation 437/97, in particular 1, 5, 16, 17, 18, and 19. His certificate was immediately revoked, and he had to submit a statement expressing his remorse. The reason I chose these cases was that even though there was a violation of Regulation 437/97 in both the cases, they are, however, distinct in nature, and therefore different information was learned as a result. In Case 1, the member did not honor the ethical standard of care, trust, respect, and integrity, and as well as the standard of practice. She showed no compassion and empathy to students and demonstrated no responsibility when dealing with other members of the profession. Teachers are held to the highest levels of ethics, including trust, integrity, and morality at all times. Even though the member in Case 2 did not harm any member of the school, his conduct was a serious breach of trust of the public and the school community, hence also dishonoring the ethical standards of trust, respect, and integrity. As a teacher in Ontario, both the cases gave me an understanding of the legislative framework that governs the education system in Ontario. They helped me identify and analyze laws and regulations that are related to teaching. They also helped me analyze and apply other legal principles and ethical standards that are related to education. In addition, the Case 1 highlighted the importance of upholding the ethical framework and standards of practice. It set a precedent for me and other teachers as to which actions are considered unacceptable and unprofessional as a teacher in Ontario and the repercussions of such actions. Case 2 in particular shed light on a very disturbing reality and demonstrated how the Ontario Court of Justice and OCT has zero tolerance for the despicable crime of child pornography. It also demonstrated how to support the students and ensure their safety and well-being when a member of the school community is convicted of a similar offense. Both the cases give me an understanding how the 2 different offenses were treated by the discipline committee and what penalties were imposed as a result. For example, in Case 1, the member was reprimanded and the certificate was suspended for a month, whereas in Case 2, his certificate was immediately revoked. He was also sentenced to 6 months incarceration by the Ontario Court of Justice. Besides the Ontario Regulation 437/97, following on the other legal and ethical implications. In Case 1, the member did not fulfill the following duties as a teacher under the Education Act Regulation 298. She also did not follow the ministry policy of respect, civility, and responsible citizenship under the standards of behavior stated in ppm 128. Besides breaching the ministry policy of respect, civility, and responsible citizenship, the member in Case 2 also committed criminal offenses as mentioned in the subsection 3 of Child and Family Services Act and under Section 163 of the Criminal Code. Following are the list of references for my presentation. Thank you for listening to me.